Mediation and the arts of settlement. When you get to a point where you kick ass and you're really comfortable and competent, settlement will be the only option that they would approach you from. And settlement, if you're engaging in a battle in a prudent manner, in a wise manner, settlement would be your end goal. There are three main ways where one can make the ends of settlement meet. The first way is through a private settlement agreement where they will speak to you through email. That is only done when the acting judge basically trusts that you are competent enough. And that is based on something called a joint status report, whereby after you've met in a private and you've done one thing or the other, if you did not agree, you'll do a joint status report, and then that would, and oftentimes with that, the acting judge would not want to see what you've spoken about because they would want to stay neutral. But the only medium the acting judge can interact with what you've dealt with them in the private will be based on that joint status report, which will basically say, this is what we've done privately, and this is where we are right now. This is where the plaintiff stands, this is where the defendant stands. The defendant has offered the settlement of this amount, but the plaintiff refused, or whatever it is. And by the way, joint status report is the next step that's taken as one of the tools in the public venue to enforce notary presentment. But that is for another day. The second method is called mediation, which apparently a lot of people have been introduced to, yet are not sure of it. The examples that I'll be going over in this video will be specific to the states where people ask the questions. So this is a direct response to those. People, I guess they've read something about mediation, have heard someone speak of it loosely, but nonetheless is another step that you could take to be effective. Representatives of that mediation center, or the mediation, which they use a substitute word for, which is alternative dispute resolution, ADR. The representatives of that mediation are usually court appointed, but some people are afraid of going in front of a judge. Some people are afraid of, really actually doing the battle on pen and paper. So they seek mediation out. But let me tell you something very important about mediation. Mediation will not occur unless you've proven that you can actually win, unless there's a very good chance that if you were to take the battle and do it formally, you will kick their ass. That's the truth behind mediation or any type of settlement. Because mediation would usually lead to one thing and one thing only. Just like the private settlement agreements that gives birth to joint status reports, it gives birth to settlements. That's the only purpose why you will go privately to them or do a mediation. The third type that would basically be used as a means to an end is the judge's chamber, whereby you would specifically and deliberately require and request that, and none of the things that you deal with would not be on the court docket, with the exception that the acting judge would actually be present compared to the first type. But let's omit and ignore the first type of means to an end of settlement and ignore the third type of means to an end of the settlement. We are currently in the advanced stages of things now. Regardless of whether someone has heard about mediation or not, don't tread on it lightly, because if you screw up a mediation, they can, even though it's supposed to be a private interaction, they can take those engagements within mediation and use it against you in court. You don't want to make that mistake, and you don't want to presume that mediation is the end all be all to your solution. As it's always mentioned, competency is always the key, no matter what you do. So let's start from ground zero, and we'll isolate the subject matter to just mediation, rather than the other two types to reach settlement. I personally prefer the first and the third, but for whatever reason, there's just this fear in people where they I don't know what it is. They want to run around things, but nonetheless, based on the questions that's been received, here is the response. Starting from ground zero. Mediation. Mediation is mitigation. Settlement is mitigation. To get a judgment against them, it's called litigation. You want to always win by mitigation, not by litigation. Litigation is not necessarily the act of you filing a suit. Litigation is if you've completed the intent of that suit, then you've litigated the matter. Mitigation is when you filed a suit or did prerequisite things that will lead up to the suit, but before finalizing the suit, you came to a meeting of the mind with the other party. This thing called mediation, which is the second form of settlement, as far as my experience goes, is a form of mitigating things. Mitigating things in the sense that it limits damage on their end and it limits too much effort and risk on your end. It saves time and it saves resource. A win-win situation. It is a form of treaty. Believe it or not, mediation is a type of treaty. When you put pen to paper, you have effectively went to war against someone. And treaty does not necessarily have to involve cannons, bombs, and all that. So long as one man or one woman is mentally determined enough to accomplish any given goal, and you're willing to go through any extent to get it done, of course, lawfully and legally and spiritually. Never forget the spiritual aspect, which we'll be going over how you can use black candle, rotten nails, and cayenne pepper in the future to actually get things done. But mediation is mitigation and is a type of treaty when it comes to pen and paper. Why and how? Ballantyne's Dictionary from the year 1968. 1968, because some of the case laws regarding settlement that I find to be very effective is from around the year 1962 all the way to about 1980 something. So the dictionary around that time period will be used to make reference to settlement. Mediation, the settlement of disputes between sovereign nations by the arbitration thereof. See 30 American Jurisprudence, Revised Edition, International Version, subsection 52. Specific to mediation of labor disputes. You know, one of the most important factors when it comes to mediation that you'll be bringing up is the fact that you're wanting to preserve time and resource. Time and resource in legalese is synonymous with labor, because litigation, pen and paper game, is laborious, and that will be part of the claim. So a naked eye might read this and think has to do with being an employee or belonging to some group of union who fights hard for workers' right, even though it's completely turned to the opposite of what it intended to be from the start. Nonetheless, this term labor simply means saving time and resource. And when you read the rest of the cartas regarding mediation, settlement, or even anything in general, for instance, when they're trying to slap pro se in the face that you're wasting our time because you're talking a bunch of trash, they're going to tell you you're wasting a course time and you're wasting a course resource. Well, you put that same principles to use. And when you read the rest of the cartas of settlements, they will tell you one of the intents of settling is to reduce the time and resource spent, aka labor. That is the summary of what labor is. Through arbitration. What is arbitration? Same dictionary. Arbitration, a mode of settling differences, aka settlement. You see why mediation is a form of settlement? A mode of settling differences. And the reason why I actually prefer the first and the third type of settlement is because you have someone who you can attach an oath of office that's attached to the Constitution with it. See, mediation mediums are based on the local court rules, and when you really start to read how they function and how they assign the mediators, it kind of sort of becomes a bit controversial, because they're trying to use it as a loophole to remove constitutional things, and they're using the Administrative Procedures Act to do mediation. So, I mean, if you know how to navigate and do things, and your spirit game is strong and your competency is, I say go ahead and do mediation, not an issue. But preferably, I prefer the first and the third. But nonetheless, arbitration. Remember, mediation is used by form of arbitration. Arbitration is a mode of settling differences, settlement, through the investigation and determination, meaning now whoever the mediator is would now act in place of the acting judge. That mediator never has an oath of office to the Constitution. A mode of settling differences through the investigation and determination, a judge, a neutral third party, by one or more persons selected, not elected, selected for the purpose of some disputed matter submitted to them by the contending parties for decision and award in lieu of a judicial proceeding. Meaning the judicial proceedings deal with judicial notices. Judicial notices deals with undisputable material facts. Rule of evidence, Rule 201, judicial notice of adjudicative fact. Kind of facts that may be judicially noticed. The court may judicially notice a fact that is not subject to reasonable dispute. Then it cannot be disputed because it is generally known within the trial court's jurisdiction, aka the Constitution, because that's the foundation of all these, or can be accurately and readily determined from sources whose accuracy cannot be reasonably disputed based on self-authenticating evidence, which we'll run over in different ways. Taking notice. The court may take judicial notices on its own, or must take judicial notice if a party requests it, and the court is supplied with necessary information. Opportunity to be heard. Time requires so and so, blah blah blah. All this is inapplicable when it comes to mediation. Why? Because mediation is a form of arbitration, as explained right here. The settlement of a dispute between sovereign nations by the arbitration. It's basically a settlement through arbitration. What is arbitration? Arbitration is a mode of settling difference through the investigation and determination by one or more persons selected for the purpose. Meaning now they're selected specifically, which we'll be going over. In some locations, they just only have to have an associate or bachelor's degree in social work. Same people that take your children, right? In some cases, they have to just be lawyers. In some cases, they only have to be certified as a court reporter. See, mediation, which is a type of arbitration, meaning things performed arbitrarily, which is it is in lieu of a judicial proceeding, whereby you could actually present evidence, which one would reasonably presume law will be the backbone of everything you're doing, and rule of evidence will be the backbone of everything you're doing. But if you go into a mediation whereby someone is merely selected in an arbitrary manner, because it's an arbitration, in lieu of judicial proceeding, then judicial notices and the laws that comes with judicial notices is out of the equation. Just keep that in mind. There's nothing wrong with mediation, but if you're dealing with serious situation, mediation is probably not the way you intend to settle. Just keep it in mind. Unless, you see, mediation is very similar to voir dire when you pick grand juries or juries. For trial, grand jury determine a probable cause to bring any serious capital crime against someone if you're trying to charge them with unconstitutional things. Jury trial is basically the people who will determine whether the evidence is proper or not in place of the acting judge. The reason why I say mediation is similar to voir dire is you have to have a peer of yours to mediate the situation. In other words, you have to know someone who is a mediator to do it. And another thing with mediators, you can choose who you want your mediators to be. So if you are really organized and you know who you want your mediator to be and the other party is willing to agree with it, then absolutely go ahead and do it. These are the conditions behind mediation that are being given. These are the things that you need to determine if you want to settle through mediation. Remember, mediation is governed by the Administrative Procedures Act. It's just arbitrary, aka an arbitration. It's self-evident, it's self-explanatory in black and white. And guess what? It's also governed by this thing called Arbitration Act. So that maritime stuff that people want to run away from talking about it as though it's something bad. That is what you're dipping yourself into. But if your claim is strong enough, like a tort claim, then of course it applies in maritime also. What are the intricacies of what you're bringing, and you've layered the sophisticated aspect of what you're bringing is so strong that the mediator is not competent enough. Not if the things, believe it or not, some of the things that we'll be learning about here and some of the things we're speaking of here, not all judges even know about it. Only specific types of judge are aware of it. And now a mediator, you're living your whole life, your months and years and weeks of work to some random man. Now, just like a voir dire, whether it's a grand jury or jury trial, make sure that your mediator is someone that you are acclimated with. It is your peers. It does not abrogate due process on the other parties end so long as they agree with it. So now, with each jurisdiction, each state, they have their own local rules that govern mediation, which is, for whatever reason, is amiss in most people's minds when they're looking into mediation. Whatever state you're at, there's always rules regarding mediation, and there are always subdivisions of bodies that are created specifically for mediation. Remember, as we go through this, just know that mediation has nothing to do with judicial proceedings and has nothing to do with law. It's all private, meaning private contract is what determines the validity of what's going on. And just like voir dire, again, you have to have your peers if you want to do mediation. So based on the locations of those I've spoken with, here an example. At Maryland, they have something called mediation and ADR, alternative dispute resolution, as we went over. Avoiding trial. Filing a lawsuit may be the appropriate way to handle some disputes, but trials can be expensive and stressful. Remember, we spoke about labor. Labor is the expense and the level of time and energy spent. There are a number of different ways you can resolve your dispute without going to trial. Absolutely. They're telling you there are a number of different ways, plural, meaning besides mediation, there are other ways which we've mentioned. The first and the third type, towards the beginning of this videos. There are a number of different ways you can resolve your dispute without going to trial. Alternative dispute resolution, or ADR, refers to a variety of processes for resolving disputes without going to trial. Now they're confining it to what's relegated to mediation, aka alternative dispute resolution. They're not going to tell you the other types of ways for you to settle. Why should they? ADR includes mediation, settlement conferences, community conferencing. You can take advantage of some of these services even before you file a court case. Before you file a court case, the first and the third method have to actually require you to have filed a court case first. So if you don't even want to file it first, fine, not a problem. There's a solution on all ends. Just make sure whoever the mediator is one of your peers. That's all I'll say about it. Once you have filed a court case, the court may suggest or require you participate in one or more of these types of ADR programs. There are private mediators in Maryland that you can hire, This is extremely important. Extremely important. This is the crux of the whole thing. If nothing else is obtained from this, just know that your mediator is someone that you should choose. Of course, granted, the other party has to agree to it. And by you, I'm presuming you're the plaintiff. There's also a network of community mediation centers that train local community members to provide free and low-cost mediation services. They just train local people to do this. There's a reason why it's called an arbitration. It's arbitrary. The Maryland courts also operates their own mediation and ADR programs. The court may refer you to mediation or another ADR program once you have filed a court action. They may do so. So what is mediation at Maryland? Mediation is a process in which a trained impartial person playing the role of a judge, but not with judicial power, called a mediator, helps you and the other person communicate, understand each other, and reach agreement if possible. Mediation is voluntary, confidential, meaning it's a private contract. Nothing wrong with it. If you know how to operate in contract, by all means do so. The principles of contract of trust must first be comprehended in great details, let alone the specific subject matter that they want to go into mediation for. Know what you're doing, in other words. Mediation is voluntary, confidential, and lets you and the other person decide what works best for both of you. Mediation is voluntary, mediation is confidential, mediation lets you decide. What is the cost of mediation? The cost of mediation varies depending on the program. In some court, government, and community programs, the service will be free and based on a sliding fee scale. In other courts and in private mediation, the cost likely will be in an hourly basis and is typically divided by the participant. When is mediation appropriate? Certain disputes need to be heard by a court. If you're trying to create or change a law to have a public airing of a complaint, address serious criminal matters, or set precedent, or to challenge a precedent established by a prior lawsuit, mediation is not appropriate. What is a settlement conference? In a settlement conference, the people in a dispute in court or their attorneys appear before an impartial person in an attempt to resolve the dispute or issue a dispute by agreement by means other than a trial. I'm telling you, there are other ways you don't have to go to trial without using mediation. But if you want to use a mediation, make sure you hire one that's competent enough. Your peer, because this is no different than doing a jury trial now, with the exception that there's no judicial power involved. It's all based in private contract. Whatever the outcome may be, holds no judicial power in any way. So that can be good or bad. It can be good in the sense that if we don't come to a conclusion, the mediator cannot have any judicial power to set res judicata. But guess what, though? The other party that you went into mediation with can use some of that information in there against you. In fact, I've dealt with circumstances where I didn't intend to, mediate the issue, but I attended the mediation just for the sake of seeing what they have going on as a claim. So the other party, just know there's a lot of loose ends when it comes to mediation. But nonetheless, that's at Maryland. They have their own local rules and their own specific division dealing with mediation. So it is now incumbent upon you to find the phone number for that. But they let you know you can hire one. If you don't want to hire one, well, there's a program that they have to teach people in the community to do it. 2 options there. And then once you get that done, just contact them and tell them you want to access the mediation court. Literally, they have mediation courts. People don't have to make it as complicated just because they read some PDF or they heard someone talk about it in a vague manner. It's very, very simple and straightforward. But those are the loose ends for Maryland. The other location where I had a conversation with someone with is in New York. New York lays it out to you real good. Resolving your cases through mediation in civil court of the city of New York. What is mediation? Mediation is a free, voluntary, and confidential service that helps people who have a dispute to reach their own settlement. So you will see similar elements here. Instead of asking a judge to make a decision in court, the people meet with a trained mediator who helps them make their own decision on how to settle the dispute. If a settlement is reached, it is then put in writing and signed private contract with a witness to it being the mediator. Isn't this not what people try to do with a notary protest? But we'll get to that pretty soon. This written settlement then becomes a legal contract that the court can enforce. If the people in the dispute are not able to reach an agreement that is acceptable to everyone involved, they are then free to ask a judge to hear their case and make a decision in court. Who sponsors the mediation service? Oh, so they have a service specifically. Mediation services are sponsored by Civil Court of the City of New York and provided by approved community dispute resolution centers and local law school mediation programs. Local law school mediation programs meaning lawyers. Remember, you can hire yours. You can hire your own mediator. Think multifaceted. Think beyond the words being given to you without it being directly told to you. Think about notary protests, think about hiring your own mediator, and then using the ready-made medium that they have for you. Think about that. Moving on, what kind of disputes can be handled through mediation? Most non-violent disputes can be mediated. This includes but is not limited to money and non-money disputes between neighbors, family members, landlords and tenants, customers and businesses, and roommates. Disputes involving community groups and organizations can also be addressed through mediation. Mediation services are available to people who are involved in disputes that could otherwise be heard and decided in civil court of City of New York by a judge or arbitrator. Mediation services are available to people who are involved in disputes that could otherwise be heard and decided by a judge or arbitrator, meaning you can hire someone, even if you don't want to use their arbitrator, aka their mediator. This includes small claims, civil claims, and some landlord-tenant disputes. However, both sides must agree to mediation. Remember, it was mentioned earlier, even if you hire one, the other party have to agree first. If so long as they agree, and your mediator is playing a similar role as jury of your own peer, then cool, let's go ahead and do it. It's a private contract, so this is not a situation where the jury of your own peer is only relating to the supposed defendant. Since this is a private engagement, you, the plaintiff, can hire your own jury of your own peer. It's all private now. That's the beauty of rights and obligation of contract. Guess what? So long as both sides agree. Simple. It's that simple. However, both sides must agree to mediation, and in certain cases, at least one side must be handling the dispute without a lawyer. The court will let you know if a case is eligible for mediation. Mediation is free, mediation is convenient, mediation is fast. It's only 1 to 2 hour session. Mediation is voluntary, meaning the other party is not bound to come perform, compared to a formal judicial proceeding whereby once they're summoned and they don't perform, that's default right there. So you cannot compel performance in a mediation, especially an appearance to begin with, until the agreement has been signed privately by both parties. If a mediation involved agreement of both parties signing some agreement, and notaries act as witness to it, should that not tell you who you want your mediator to be? Now I'm just saying. Moving on. Mediation is confidential. It's private. Only written settlements are kept on file. All conversations during mediation sessions are confidential. Mediation cannot be ordered to testify. Mediators cannot be ordered to testify in court regarding the case, meaning whoever that mediator is held harmless. All notes taken by the mediator are destroyed at the end of the process. Mediation is satisfying. Mediation allows people to vent and be heard. Is this not what most people basically want to do anyway? If you're going to do it, just do it smart. Everything you need to do to make mediation work, believe it or not, has been given to you. It's like the only thing now is just the venue, which is like a public library when you rent out a room. That's why they have mediation centers in all these specific locations governed by the local court rules. But who the mediator is, you can hire them. If you don't hire your own mediator upon agreement of the other party, they will stick a lawyer on you, or as a mediator, or someone who is not even half as competent as you or the other party. That's an issue. Pay attention to that. Mediation works. People who reach their own settlement through mediation are more likely to comply or follow through with settlement. Who are the mediators? The mediators are experienced volunteers who have received special training in civil court dispute resolution. Some have legal training as well. Some have legal training as well. Some have legal training as well. And not all that, they don't always have to, and not all of them do. But some of them have legal training as well. Although mediators might be lawyers or law students, You know how they get interns, they're in doctor's office to kind of test and work on your teeth or some part of your body. Well, they're experimental with you with mediation if you don't bring yours in. They cannot give legal advice to tell you what to do. They may suggest that you visit the Courts Resource Center, where people who are not represented by lawyers can get legal information, general guidance, and referrals from court staff. In other words, you have to know what you're doing, or they'll give you the runaround. Because if you go to the court staff, chances are they'll give you the runaround just like the attorney did in the first place. And by the way, a lawyer just means someone who is versed in law. A lawyer is different from an attorney. An attorney is a member of a private association called a Embrace Accreditation Registering Member, who issue the international standard lawyer numbers and the bar numbers so they can do business at a specific court. And those numbers are the hold harmless agreements, by the way, in case we didn't know at this point. So that's an attorney, but a lawyer is just someone who's versed in law. But are they going to tell you this, the definition of these terms? No, they're not. But if one had not had the eyes to see, there it is right there, just so you can interpret the information properly. Where do mediation sessions take place? Mediation sessions are held in court or at a local community dispute resolution center, depending on the borough and how a case is referred to in mediation. Remember, we spoke about the venue now? You can hire yours. The only difference now is where's the venue. Just bring the one you've hired and let the people at whatever location that your local area is, let them know that both parties have agreed in writing. They give it to them, and then they'll give you a room to rent out or to kind of use temporarily. Like you just go to a public library to do that. Literally, that's what it is. It's that simple. What evidence should I bring? You should try to bring all related documents, photograph, estimates, repair bill, and other items that might be helpful in resolving your dispute. Is whoever this is going to be looking at this, are they competent enough? It's the question you ought to be asking. Because as we've read earlier within the Ballantine of Bouvier's, lets you know that they're playing the role of a judge without judicial authority. Do I need a lawyer or a witness? No, you do not need to have a lawyer or witnesses present in a mediation. Parties are encouraged to speak for themselves and to come up with their own resolution. However, although lawyers are not necessary, they are welcome to participate in the mediation and to help with problem solving. Is a mediation substitute for seeking legal information and advice? And then they're so kind enough in New York to even give you the location of the mediation areas. So there's your response right there for the lady who needed it for New York. At Illinois, they literally have something called a civil division mediation program. Applicability. As intended to govern mediation in civil matters, except where a more specific rules applies, unless otherwise addressed in these rules, the provision of the Uniform Mediation Act. So in Illinois, they specifically have an act regarding mediation. Right here, shall apply, meaning they have their own administrative rules that govern mediation, and they give it to you. Let's zoom this in just a little bit. A. Judicial authority. Listen to this. Nothing in this rule shall limit the court's authority to enter any order it deems appropriate on its own motion or on any party's motion. Purpose of mediation process. Mediation under these rules involves a confidential process, meaning it's private. It's a private contract, whereby a neutral mediator selected by the parties, meaning they have to agree to who it is, or appointed by the court, assist the litigants in reaching a mutually acceptable agreement. It is an informal and non-adversarial process. The role of the mediator includes, but is not limited to, assisting the parties in identifying issues, fostering joint problem solving, exploring settlement alternatives, and reaching an agreement. Parties and their representatives are required to mediate in good faith. And then it tells you that it can be by court order, or you can do it voluntarily, and then tell you if it's by court order, then they're going to give you a specific time period, which is 7 weeks, where they've referred you to the mediation. And then they'll give it a time and date for it to take place, and there's a formality to it. Literally, they're giving you the rules for like civil procedures on a state or federal level, or rules of evidence on a state or federal level will give you basically the guidelines of how they perform. Well, mediation courts have their own guidelines, and this is it right here. Some states go into the details of it or not, some don't. At Illinois, they do a very beautiful job of going into details. I'm telling you, you can do motions within mediation meetings. The party may move within 14 days after the order to refer dispense with mediation if the issue to be considered has been previously mediated between the same parties pursuant to local rules of the 19th Judicial Circuits. Local rules govern it in addition to the Mediation Act mentioned above. Some states don't have Mediation Act. If they don't, then it uniformly uses the Administrative Procedures Act. Within the states that do have the Mediation Act, the Administrative Procedures Act becomes secondary. Mediation rules and procedure. Then it goes on, the mediator. The mediator shall at all times be in control of the mediation and the procedures to be followed in mediation. Appointment of mediator. Within 14 days of the order referred, that is, if you did not go before starting a court case and then requesting for mediation, the parties may agree upon a stipulation within the court designation a certified mediator. A mediator who does not meet the certification requirement of these rules, but who, in opinion of the parties and upon review by and approved by the presiding judge, is otherwise qualified by training or experience to mediate all or some of the issues in particular. So, if you formally open a court case first and you refer mediation, then the presiding judge at Illinois would determine the qualification of the mediator if they don't appoint it. But keep in mind, you can hire your mediator and you can enforce mediation before or to prevent opening a court case. It's all private contracts now that you just have to go to the venue designated for mediation according to the local court rules and tell them you want to engage in mediation. Simple as that. Compensation of mediator. Each mediator shall agree to mediate 2 cases per calendar year without compensation. When the mediator is selected by the parties, the mediator's compensation shall be paid by the parties as agreed upon between the parties and the mediator. When the parties cannot agree on the mediator, the court, meaning at this point now, if you haven't opened a case formally, or if you have formally opened a case and you can't agree upon the mediator because the other party thinks, well, you're trying to cheat me by bringing someone who is biased, then in that case, the court shall appoint mediator from the list of the mediators as provided in local rule 7-5, blah, 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 of these rules. The compensation for the mediator so appointed shall be shared proportionally by all parties participating in the mediation conference. Once a mediator has been appointed, the mediator shall be entitled to a minimum of 1 hour's compensation. If any party has been granted leave to sue or defend as a poor person in form of paupers, pursuant to Supreme Court Rule 298, the court shall appoint a mediator who shall serve pro bono as to the party. Any such appointment credited towards obligation under the local court rule, as mentioned earlier. The fee of an appointed mediator shall be subject to appropriate order of judgment for enforcement. These are the joint responsibility of each party and his counsel. Disqualification of mediator. You can disqualify them. You can do emergency relief. Then it goes into the details. Illinois does a very, 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 very good job of going into the details. So that's that for the one who asked about Illinois. But on the case of Illinois, let me show you something else. Have you ever heard of this thing called ex parte judgment? In arbitration, mediation, you can actually do that. Court Annex Civil Mediation Process. Unlike a judge, the mediator is not limited by ex parte communication. The mediator can meet caucus with parties and counsels individually, confidentially discussing underlying issues and concerns. Meaning ex parte judgments can occur, meaning you don't both have to be present in order for the mediator to do their job. Remember, it's all private contract now, meaning it's less formal. In caucus, the mediator can gain insight as to the parties' motivations and goals, then use that information to confidentially explore settlement options with each side before any formal offer is made. Mediation typically demonstrates high success rates. Several circuits have reported that at least 50% to 65% of cases referred to mediation have resulted in either a full or partial agreement. A mediated settlement can save parties significant time, expense, and effort, even if a settlement cannot be reached in mediation. Many mediated cases settle at a subsequent judicial conference, still avoiding the time and expense of a later trial, aka labor, as we've read earlier. Actions eligible. In Illinois, that is. I don't know much about the other states, but at Illinois, the Circuit Court of Cook County, major civil cases seeking damages in excess of $30,000 are eligible for referral, and so long as it's more than $30,000. And it's so flexible in some situation that the mediation site, the venue, mediations may be conducted anywhere the parties agree. Kind of like when they take dispositions and whatnot, where you can take it anywhere. Well, mediations can be the same way, either at the mediator's office or mandatory arbitration center, meaning they have locations regardless of where you are, regardless of what states. Certain attributes are similar, which is you can either go to the court and request mediation, or you don't have to open a case and do a mediation and present a private contract to the center, and there's always a venue for it. Or you can hire your own or get them to assign one for you. That's basically a summary of it. But if you're going to do mediation, again, we'll keep repeating, treat it like you want a jury of your own peer. And usually a smart opposition to you would not agree to the one you choose. They just wouldn't, because it's all private contract. And if you enter into that private contract that's witnessed by someone else, it's binding as a private contract based on rights and obligation of contract. So odds are that now you probably be in a situation where now the court has to appoint it. You just hope they appoint someone competent and beneficial. Then they go into the details of the provisions and whatnot, settlement and all that. And for Illinois, Cook County, they give you the information. Now, what if, under any given circumstance, you and the other party just can't agree on the mediator that you chose, and you think for whatever reason you don't want to use a court-appointed mediator? Well, you have a third option. The third option is there are always entities that are created just for mediation purpose, although they're most likely going to be lawyers also. And keep in mind, they all belong to Masonic lodges, and they all belong to the same organizations. But nonetheless, if you really don't want the court to appoint it, there are usually private mediators and entities who basically work as independent contractors. And it tells you here at Illinois, private mediators means a person or organization providing mediation services. A person or organization providing mediation services other than family mediation service with the Circuit Court of Cook County shows, which offers mediation at no charge. In other words, you can go to any organization that is known to provide mediation services. So that's that. Now, what are the qualifications of court certified private mediators, meaning the ones that the court appoints? Meaning, they certify them as being competent enough before they appoint them. So court certified private mediators are the same thing as court appointed mediators. Certified mediators shall possess the following minimum qualification and shall serve at the discretion of the presiding judge, which is the one who assigns them here at Illinois. And here are the qualifications. Illinois license as an attorney, psychologist, social worker, or, meaning one of these other ones, or marriage and family therapist, depending on the specific subject matter dealing with domestic relations. 3 or more years experience in mediation, applicable profession. Completion of a minimum of 40 hours mediation training program as approved by the presiding judge of the Domestic Relations Division. Completion of continuing education, blah, blah, blah. Knowledge and competence in the following area applicable to the issues to be mediated and in identifying impediments to mediate, etc., etc. So there are either attorneys, psychologists who looks at human nature, engaged in hypnosis one way or the other, social worker, or if you're dealing with domestic situation, marriage and family therapist. The fourth situation where I had a conversation with someone is in Indiana. Mediation and alternative resolution. At this point, one should at least basically see the consistent pattern. At Indiana, they tell you, did you know that most civil lawsuits settle without a trial? Did you know that you don't have to always try your case in court in order to solve your disputes? Other ways to resolve lawsuits are known as alternative dispute resolutions, also called ADR. ADR is a general term which includes mediation, facilitation, and other out-of-court strategies for resolving cases without going to trial. That's right. ADR allows the parties to play a more active role in resolving their dispute in a more informal setting, private setting. That's what they mean by saying more informal. Cases can usually be resolved more quickly when ADR is used. An ADR trained impartial persons to decide disputes or help parties decide disputes themselves. These persons are called neutrals. Neutrals are normally chosen by the disputing parties by the court. Neutrals are normally chosen by the disputing parties or by the court. Neutrals can help parties resolve disputes without having to go to court and follow the formal courtroom procedures. You often have more time and flexibility to fully explain your side of the case without using ADR than you would in court. One of the most popular forms of alternative dispute resolution is mediation that we've just defined and went over. Mediation is an informal process, aka private process. Let's pause for a moment here. This word private process, it's like a stimulant for people that kind of makes them a little bit jittery. This thing, private and private processes, is exactly what's being done to people to screw people over. So when people hear private things or private process and they want to engage in it, do know that if you're just jittery about going into private processes and things like that, it can still be used against you, because private contracts are far more stronger than any other type of contract. So going into mediation, you still have to be competent. You still have to be in your A game. You still have to comprehend that certain etiquettes exist. Even though it's not formal, you still have to use this basic etiquette, because these mediators, especially if it's court appointed, they will go back to the people who appointed them and give them a report, because it's all private contract and they're not obligated to tell you that they'll be reporting back to the other party. Just so you know, mediation is an informal, aka private process, in which a neutral third party, known as mediator, helps you and the other party reach an agreement on some or all of the differences. In the mediation process, the mediator helps the parties identify important issues, clarify misunderstandings, explore solutions, and negotiate a settlement, rather than having a costly and time-consuming trial, aka labor, as we went over the definition of arbitration within American jurisprudence by way of Bouvier Dictionary. In mediation, decision making by the parties must be voluntary, so only those issues upon which both parties can agree will be included in the settlement. For a complete explanation about the cost of mediation, the selection of mediation, the mediation process, and other issues about mediation, please read Indiana Rule of Alternative Dispute Resolution. They either have state public law statutized that deals with arbitration and mediation, or they have local rules, which you have to be familiar with. Anyone telling you about mediation and they're not telling you to read the state laws regarding mediation and arbitration and the local rules regarding mediation and arbitration, and are not telling you these details of how it goes, they're just either speaking real cool to sound cool, throwing you a bone. And when you jump to bite it, make sure that you land on a solid surface and you don't land in quicksand, because most people who go and bite that bone when they hear things like mediation, when they read PDFs or social media, so and so, they jump to go bite it, but they're not looking at where they're landing. So knowing where you will land is knowing that mediation is governed by its own set of rules, and it is private. I'm telling you, whatever you do in a private venue is far more binding. See, there's a little bit of solutions and whatnot when it comes to rule of evidence, when it comes to public settlements, when it comes to formal settlement of disputes, which are the first one and the third type that we spoke of earlier in this video. So the second one, mediation, it works. It really works. And it's best if you have your own peer to do it and the other party agrees to it. I've been repeating it because it's an extremely important element to make mediation work. If you don't put it to use in that manner, when you go into mediation, it might not turn out the way that you think. I'll just give you that heads up. Then it goes on to tell you that they have programs for low cost or no cost mediation. So those are the locations where conversations have been had with people: Indiana, New York, Illinois, and Maryland regarding mediation. But nonetheless, regardless of where you are, you see the consistent pattern and necessity of still being able to do certain things. Mediation does not abate you of any liability of your agreement that you enter into, and certain foundational principles of a contract and trust must still nonetheless be put into consideration. Until next time, take care. Best of luck.